Good afternoon, everybody, and welcome to Lawyers, Guns, and Money Fall 2025 session. We really appreciate you taking the time to join us this afternoon. I'll be your moderator, Karen King from King Condo Management. And with me today, Gersh Sandhu and Tony Boy have dedicated their time to talk to us today. A little bit about your speakers this afternoon. Our first speaker, Tony Boy from Common Ground Condo Law. Tony is an accomplished litigator with a deep expertise in condominium law, having represented clients at every level of court in Ontario, as well as before numerous administrative tribunals. Tony is known for providing clear, practical solutions that go beyond the legal framework, helping communities navigate operational risks and resolve multi-party governance disputes with confidence. Welcome, Tony, and thanks for joining us today.
Thanks for having me, Karen.
Our next speaker is Gersh Sandhu, a condominium lawyer with Elia Associates. Gersh works closely with condo boards and property managers across Ontario as well, helping them navigate the real-world issues that impact our communities. Everything from governance challenges, shared facility disputes to enforcement, contracts and employment, human rights matters. Gersh has covered them all. Welcome.
Thank you.
And a special thank you to our sponsor, Property Right. These presentations are made possible through their generosity. So support of our education is greatly appreciated. Thanks again, Property Right, who provide great condominium services to owners such as yourselves. And with that, we'll get to the really interesting part of today's presentation. So as you know, the purpose of this seminar is to review key condominium court decisions from this past year and to inform condominium corporations and stakeholders. It is really important that we stay updated. Understanding the legal precedents helps condominium boards and managers navigate our evolving legal landscape and help us do the best for our communities. One of our very interesting topics of 2025 has been harassment, dangerous conditions, and safety compliance. So Tony, would you please start us off on that one?
I'd be happy to, and thank you for that, Karen. So to start things off with a bang, I'll be going through some of the seminal cases with respect to harassment, dangerous conditions, and safety compliance over the past year. Generally speaking, I'm sure everyone in attendance is aware that a condominium corporation has a duty to protect its staff and its residents from chronic harassment, intimidation, unsafe behavior, and threats to safety, or as I otherwise lump them under the Condo Act, what we consider dangerous conditions. So the cases that we'll be discussing deal with harassment, but not just your petty harassment, such as sending multiple emails, pestering the manager, but some pretty salacious stuff here. And these cases are important because even though harassment isn't a new problem in the condominium world, the courts, we see that the courts are becoming increasingly willing to issue stern compliance orders and condemn any form of harassment in condominiums. Part of me thinks that relates to the unfortunate incident at the Vaughan condominium a few years ago, but I won't speculate. Whether or not it's a direct result of that, we know that the courts aren't keen on harassment, and neither should condominium boards, managers, or any residents. So, with that said, why don't we start things off with Hastings Condominium Corporation number 4 v. Boyce. And this is a decision that's hot off the presses. The decision was issued earlier this month on November the 3rd. So to give everyone some background here, the condominium corporation sought compliance orders against the owner because the owner refused to allow the corporation to mow his exclusive use common element yard. His argument was, among other things, his cats preferred long grass and that the owner was protesting how the condo treated him. The owner also obstructed urgent access to a common element sump pump within his unit that also served other units, and the corporation required immediate access during a flood. So we can sort of get a sense that the tensions here run deep. But when we take the owner's harassment into account, his harassment included videotaping contractors and their employees without their consent, while those individuals were working on the common elements. The owner also approached members of the board at their units and on the common elements to accuse them of mismanaging the corporation's funds. In one particularly inflammatory email, the owner said that the board was, and I quote, 100% plus, devoid of honesty, integrity, trust, accountability, and conscience. In his words, even that assessment is too complimentary. But to take matters further, and this is where I find he goes far beyond the pale, is when he makes a threat to the board. He says, since you insist on playing Russian roulette, Gaza, yes, he referred to the board as Gaza, he goes on to say, you accept the consequences, which will also be borne by the board members, your lawyers, management, etc. So we don't have the most pleasant owner here. And the key issue in this application was whether the owner breached the Condominium Act and the corporation's declaration of rules in harassing the board and the corporation's contractors, refusing to allow maintenance of his yard, and refusing to allow access to his unit for maintenance of his sump pump. In short, the court concluded that yes, this owner did breach his obligations by refusing to allow access to his yard so the corporation could maintain it. And he was also found to have breached his obligations by obstructing access to the sump pump, despite urgent flooding concerns. Now, the big ticket item here is the harassment. And in that regard, the court found that the owner's conduct was a breach of Section 117. With respect to the email I just referenced, the court considered this to be written abuse, and it declared that the owner breached sections 19, 117, and 119 of the Condo Act, and the owner was ordered to allow access to his yard and the sump pump. Uh, the corporation was allowed to refer to the sheriff and the police for assistance if necessary, and the owner was ordered to cease and desist from harassing the board and limited to sending them 2 emails per month. So that sort of sets the stage for the kind of harassment that we're dealing with. That takes me to our next case, which is Peel Condominium Corporation number 96 v. Lutzi. In this case, the Condominium Corporation sought a compliance order under Section 134 of the Condo Act against the owner for a course of harassing, vexatious conduct towards the board, property management, and contractors. Uh, the owner's behavior included impersonating staff, disrupting board meetings, inundating management with hostile emails, and threatening and filing frivolous regulatory or and police complaints. Among other things, this owner poured a water vinegar mix onto his downstairs neighbor's balcony on multiple occasions, used racist language in complaining that the board would protect his neighbor because they were, quote, of the same Polish ethnicity. The owner told police that management and the board were trying to instigate and provoke him, and he threatened to drown the board with their own rules and regulations. He secretly recorded a board meeting while denying it. He impersonated the building superintendent, and he tried to hijack a town hall by shutting down the chair and directors until the meeting collapsed after less than 20 minutes. But it doesn't end there. It doesn't end there. He also sent at least 119 emails in roughly 10 months to management, lawyers, auditors, often with thinly veiled threats of contacting the police, CMRAO, or the Law Society. In one particularly vivid example, he characterized the condo lawyer's work as a gravy train, and when the when the property manager filed a workplace harassment complaint against the owner responded with by accusing the property manager of stealing cash that he claimed to have dropped into a mail slot. So the tensions boil over. Corporation brings its compliance application, and in response, the owner brings a cross application for an oppression remedy under Section 135, alleging that the corporation and its agents had unfairly targeted and mistreated him. So part of the evidentiary problems before the court was that much of the owner's evidence was hearsay. But after carefully filtering out the owner's evidence, the court still found an overwhelming proof of a course of vexatious comment or conduct that caused or was likely to cause psychological injury in breach of sections 117 and 119 of the Condo Act. And the court found that this course was the court found that the corporation's response was reasonable. The court accepted that the owner had reasonable expectations of lawful and good faith treatment, but that the corporation nonetheless met those expectations. They investigated his complaint in good faith. They sought legal advice on novel issues, and they tried to de-escalate. And that includes apologizing to him and retracting an earlier letter against him, and responding to his inquiries within a reasonable limits. The court also recognized that management and one particular director made an ethnic slur and disparaging remarks. And while that was improper, that was an isolated incident and not part of a wider pattern of targeting the owner. So it wasn't enough to constitute oppression. So after taking all of the evidence into consideration, the court found that the corporation acted fairly and reasonably. It took appropriate steps and it did not subject the owner to oppressive conduct. Ultimately, the corporation was awarded the compliance order that it sought. And that leads us to our next case, which Gersh will be happy to discuss with you. Gersh?
Well, thanks, Tony. The Ontario Superior Court's recent decision in York Region Condominium Corporation 570 in Ettore gives us a textbook example of how a seemingly routine compliance matter can quickly evolve into a multi-layered dispute involving capacity concerns, allegations of elder abuse, and competing powers of attorney, as well as serious workplace safety issues as well. This case began with your classic compliance application, where the condominium corporation sought in order to prohibit Renee Ettore, the daughter of the unit owner, from occupying or visiting the unit due to dangerous conduct. But as often happens in condo law, the plot thickened once the powers of attorney entered the picture. So Catherine, the unit owner, had lived peacefully in the condo since 2020. She suffers from Alzheimer's disease, and her physician determined that she was incapable of managing her property and personal care. In July 2023, before Renee moved into the unit, Catherine appointed her daughters Esther and Joyce as her attorneys for property and personal care. Shortly after, Renee moved into the unit, and that's when the problems began. So the corporation alleged that Renee engaged in a campaign of harassment and intimidation, including following, photographing, and harassing the property manager, repeated unfounded allegations of misconduct and elder abuse against management, mistreatment and impersonation of Catherine in emails, installed cameras throughout the unit, including in Catherine's bedroom, and isolated Catherine and moved her into the smaller bedroom. And so the corporation characterized this behavior as a breach of Section 117 of the Condominium Act and as conduct that exposed the corporation to potential liability under the Occupational Health and Safety Act. Because yes, harassment of employees is not just a condo issue, it's also a workplace safety issue. And so before the court could even address the compliance issues, it had to deal with the surprise twist. Renee actually obtained new POAs from Catherine mid-proceeding without notifying Esther, Joyce, or the corporation or the court. She then attempted to use these new POAs to displace her sisters as Catherine's litigation guardian. YRCC 570's counsel argued that the POAs were obtained under suspicious circumstances, and the court did agree with that. The court emphasized, one, no motion had been brought to remove Esther and Joyce as litigation guardians, and two, Renee's interests conflicted with Catherine's interests, given that Renee's behavior was subject to the application. So as a result, the court refused to recognize the new POA for the purposes of this litigation. And while the court did make a final ruling on whether the new POAs were valid, generally, the court underscored the importance of safeguards when capacity is at issue. So the court found that the evidence clearly established, one, Renee engaged in harassing, intimidating, and disruptive behavior. Two, her repeated denials did not overcome the objective evidence of her conduct. Three, the fact that the police had attended the unit multiple times but didn't lay charges, it didn't diminish the seriousness of the corporation's concerns. And four, Catherine lacked capacity and could not control or address Renee's behavior. So ultimately, the court found that both Catherine as the owner and Renee as the resident to be in breach of the act and the corporation's governing documents. However, the court did not fault Catherine personally, recognizing that she lacked the capacity to control Renee. The court went on to order that Renee must vacate the unit. She may only visit her mother with the express consent of wire CC 570 and full indemnity cost of approximately $30,000 payable jointly and severally by all respondents. And yes, when the court says full cost, it does mean it. And so some quick key takeaways that I wanted to bring up before jumping into the next case. One, condominium disputes increasingly involve issues of elder care, capacity, and mental health. And it's the boards and managers who are often the first to see when something is not right in a unit. Two, boards have a duty to protect vulnerable residents and to provide a safe workplace. And so that applies under both the Condominium Act and the Occupational Health and Safety Act, because harassment of staff is never just a condo issue. Three, unit owners remain responsible for the conduct of occupants and guests, regardless of fault or personal capacity. So even when an owner is incapable, the legal responsibility for the unit doesn't disappear. Four, the corporation should adopt a clear anti-harassment and anti-violence rule. That applies to really all condominium corporations, but this case is really the perfect reminder that harassment is a safety issue, it's a workplace issue, and condominium governance issue as well. And so a dedicated rule would help the corporation act quickly and effectively. And lastly, when capacity is in question, safeguards do matter. So suspiciously timed POAs would be scrutinized, and litigation guardians can't be displaced without proper procedure. And so if there is one thing that this case teaches us, it's that condo living is never dull, and every compliance file has the potential to turn into a mini family law meets health law meets workplace safety proceedings. And more importantly, it shows that boards and managers play a critical frontline role in safeguarding residents, especially for vulnerable ones. And maintaining safe and respectful communities is definitely important. Back to you, Tony.
That brings up quite a few of the issues on harassment and dangerous workplace, and boards and managers often get in a lot of hot water in that area where they're looking at so many different types of employment issues and legal litigation and really need your assistance in doing that. We have some great questions in the chat as well. If we could please put the three cases that were referenced under this topic back up on the screen, that is one of my requests. Another one, you've touched on this a lot, Gersh. Somebody put in the question, what to do when facing harassment via emails and phone calls. So you mentioned quite a few of the steps that are there. And Tony, you also mentioned a couple of the things not to do, such as getting insulting or taking it personally, even though in your case that was at least set aside as isolated incidents. It is really important to remain calm and realize these are the set steps, and this may have more to do with the person than the situation to try and address it. But do you have anything additional to add to that question? What to do when facing harassment by emails or phone calls?
Yeah, I guess for me, the beauty of emails and phone calls that they usually come through this device. And If I see a message or a call from someone I don't want to speak to, it's as easy as putting my phone down and not picking up. And I appreciate that without having to directly deal with a situation where I'm being insulted, there are false allegations being raised against me. The point that I'm trying to make is that oftentimes it's easier to de-escalate a situation by walking away if it doesn't warrant a response. Uh, Time and attention is money. You can't get that back. So and this is me speaking personally, it's if I know that something isn't going to be productive or beneficial to me, I tend to ignore it. Now, you can also ignore a harassing email and a phone call, but still take action after the fact. But generally, when it comes to harassment, document it. If you're being harassed by an owner, make sure you have notes of what's being said, speak to your property manager, and if it needs to be referred to legal, at least you have the evidence and the documentation for them to take action.
I'll throw a quick comment in there as well before we jump into the other cases. I think it's important to at least start with respect because if you show respect, you usually get it back. So that's a good starting point. If it really does escalate, get your legal counsel involved. But sometimes you also have to call harassment for harassment. Just if you're getting emails, you can say it to that owner or whoever is emailing you and call it for what it is. Because when you put it out there and you because it's also possible that that individual might not even realize that their conduct is harassing in nature. They might not see it. It might be just so normalized for them. So just respect and can go a long way to de-escalating, like what Tony indicated, but also just call it for what it is if you need to.
Wonderful. And that works on de-escalating a lot of situations, just labeling the behavior so the person realizes it. Yep, removing yourself from the situation, staying calm, and having good rules and background. And absolutely tell your condo manager because you may not be the only one who is experiencing this. And it is good to have a central source of communication. Another thing that we tell board members, to your point, Tony, maybe you don't want to be in the path where conflict is right in front of your face. A lot of condo management companies say, bring your communications to the condo manager. They'll bring it to the board as a whole at the next meeting.
Mhm.
And that does allow the board members to be neighbors and parts of the community and be board members at the board meetings to avoid these dangerous and unsafe situations that do ruin their home. Another question that we had on here was potential legal consequences for the sender of those harassing emails and phone calls.
Well, from what we've seen from these cases, if the corporation were to bring a compliance application, whether the harassment is something that's within the scope of the CAT or it's within the scope of the Superior Court of Justice, corporations have strong enforcement options. Ultimately, if the application goes all the way to a hearing and a compliance order is awarded, not only is that owner bound by that order, they might face cost consequences against them. They might be prohibited from having any contact with management or the board of directors. And to circle back to that point about costs, if the owner doesn't if the owner doesn't pay the costs award, the corporation could register a lien against their unit. And usually when it comes to the monetary penalty, that tends to be the biggest deterrent for ongoing breaches. So there are options. Candidly, they go through the legal routes, and it isn't always the quickest, but they're powerful when they're necessary.
And I'll add to that as well. I think Tony hit it for the most part, but also the context of harassment it's so broad. You can see harassment in public, like it could be during an owners meeting, and because if it's in the public realm, you can even move harassment and turn it into like a defamatory claim as well. So there's one avenue. But you can also there might even be websites out there where where owners or residents are getting together and they're commenting about certain directors. Defamation can come up in that situation too. So harassment and defamation can sometimes be tied together.
Okay. We'll take one more question on this topic before moving on. Patricia says, we are an NORC condo community, lots of vulnerable seniors. Are there any general practices a board should consider that would be an early warning system for potential issues? I think on
That's
that
an
one, we've
interesting one.
covered documentation is a key thing
Mhm.
to, as an early warning system, the first couple incidents.
Mhm.
I think on a preliminary level, showing that respect to everybody. I know we've all had difficult clients that come in and they're hot for whatever historical reason or experiences they've had in the past. And to your earlier points, gentlemen, sometimes if you just show them enough respect, those people do understand that you are working for them and trying to help them.
Mhm.
And for the ones that don't, those are the ones sadly that do get escalated in terms of early warning. Do you have anything else to add for early warning systems that you might have thought of?
Um, no, I think you hit the nail on the head there. It's respect, and even just a response is often enough to disarm a disgruntled owner.
Mhm.
But to put a finer point on some of the suggestions that Karen and Gersh have raised, it's yes, there's a lot of value to being respectful, to being responsive, to being compassionate and understanding. But keep in mind that when you're dealing with harassment, your personal safety is the single most important thing, and that's something that you shouldn't take any chances on. If you feel as if your safety is in danger, don't hesitate to contact the police or to remove yourself from the situation. There's a time for reasonableness, there's a time for responsiveness and cooperation. But sometimes you need to protect yourself. Sorry, always you should be protecting yourself first.
And I'll just add to that really quickly too. Um, I think it's really important also to provide a response with the right amount of context because sometimes context is missing. You might have one perspective
Mhm,
and they might not see the full picture. So giving them the right amount of context would help to de-escalate matters too, where you don't have to kind of go into like other avenues which involve the police, involve legal counsel, etc. So respect counsel and context would be important.
Great advice. We do have some other really good questions, but in the interest of time, we'll move to the next topic and see if we have time for those ones at the end. So our
Okay,
next topic
so
will be the CAT jurisdiction, chargebacks, and the Human Rights Tribunal.
all right, so I'll start this off by discussing the Lengyel v. Cat case. So this is an application that an owner brought against the cat. Not against a condo corporation or another owner, but against the actual condo authority tribunal. So, for context, this owner applied to the Human Rights Tribunal alleging discrimination by the cat regarding an accessible visitor parking dispute at her condo. The Human Rights Tribunal previously dismissed this application on the basis of adjudicative immunity and lack of jurisdiction. This owner wasn't content with that decision, they so this decision that we're discussing deals with the owner's request for reconsideration. In essence, the owner asked the Human Rights Tribunal to reconsider its earlier dismissal, and the owner's argument was that there's new evidence and a brief medical note indicating that the owner required care on a date after the original decision and that her prognosis was unknown. But the problem is this new evidence, whatever value it might have, it didn't address the Human Rights Tribunal's jurisdictional concern. And the Human Rights Tribunal bluntly stated that this new evidence does not impact the tribunal's decision, that it lacks jurisdiction to review decisions of the CAT because of the doctrine of adjudicative immunity. And the Human Rights Tribunal went on to further state that this owner was essentially trying to relitigate the CAT's decision, which was already done. So the Human Rights Tribunal refused to reconsider the owner's human rights complaint. Now, before I get into the overarching importance of this decision, we have to recognize that there is an overlap between the Human Rights Tribunal and the Condo Authority Tribunal. to the extent that for any matters before the cat, and let's use pets, for example, pets and accommodation. The cat has the legal jurisdiction to consider accommodation factors. However, this does not mean that the cat is replacing the Human Rights Tribunal. It can only consider those factors where it relates to a dispute that's already within its jurisdiction. So, for example, if we're dealing with accommodation for pets or parking, then yes, the cat can consider human rights issues. But if an owner feels their property manager is discriminating against them, say on the basis of race, it doesn't mean that they can go to the cat. That is properly before the Human Rights Tribunal. So the reason why we believe this case is important to consider is because owner and condominium disputes are often extremely personal. And when you're dealing with self-represented owners, they may do whatever they can to retaliate or pursue what they perceive as justice, whether or not those processes are proper. Regardless of whether they're proper, though, this forces the board and management to spend their limited time, money, and effort to respond to these legal proceedings. And that's not to say anything about the stress that might come with this. So, with this in mind, I always recommend try that I always recommend that boards and managers try to de-escalate disputes before they reach this point of no return. While that's not always possible, and sometimes firm, assertive action is required, the idea is by de-escalating a dispute, you might avoid having to deal with these far-reaching headaches altogether. So, on a similar note, that segues into our next case, which is Turgay v. Toronto Standard Condominium Corporation, number 2288. So it's important to, again, keep in mind that the CAT's jurisdiction is very limited to specific disputes, namely records and nuisances regarding what I consider the three P's of condominium living, being people, pets, and parking. So in this case, the corporation issued a demand letter to the owner regarding their harassment. Now, full disclosure, this is a matter that I handled. So to give everyone some context that's not in the reported decision, the demand letter noted that this owner told concierge to get my package, you little bitch, and repeatedly referred to concierge as my personal security bitch. I need to scrub my mouth with soap, but that gives you a sense of just how nasty this harassment is. The owner also threatened to remove concierge from their position at the condo, threatening them with a statement: "You do not know my business and do not mess with me, or you will be in trouble." Nasty to say the least. In short, the letter demanded that the owner have no contact with concierge and warned that the owner would be held responsible for the corporation's legal costs if their breaches continued. Now, I want to note that the corporation didn't charge back the cost of this demand letter, nor did it register a lien against the owner's unit. This was a very clear warning that of the potential consequences the owner faced if this behavior continued. But despite the fact that the corporation didn't charge back the legal letter or register a lien, the owner commenced a CAT application challenging the corporation's right to charge back the letter or register a lien. And the owner also complained of unlawful restrictions on their right to communicate with staff. The owner's application was framed as the corporation's alleged breach of Section 117 sub 1 of the Condo Act, being the prohibition against dangerous conditions and activities. However, the issue before the CAT was whether it had authority to adjudicate what was effectively a governance failure, notwithstanding the fact that the owner framed their application as a dangerous condition. So again, Section 117 sub 1 deals with serious health, safety, or risk of damage to the property, premises, or persons. However, the tribunal's jurisdiction doesn't extend to disputes relating to broad governance failures or disputes. The CAT concluded that it lacked jurisdiction over this application, and the application was dismissed for want of jurisdiction. So this is a great example of the CAT maintaining its clear boundaries and jurisdiction and dismissing applications without requiring any submissions from our client. Now, things aren't always this clear, and not every case will be this lucky. So while some disputes are unavoidable, this takes me back to my initial point that it's always best to avoid legal proceedings as much as possible.
Okay, and that takes us to the Ontario Superior Court's recent decision in Waterloo North Condominium Corporation number 37 in Baja. And that was a review of an appeal from the Condominium Authority Tribunal. And so the issue for judicial review was whether the CAT was correct in dismissing the Condominium Corporation's application to remove a second dog from a unit where the resident claimed disability-related accommodation. And so this is there was a one dog rule, and it combined that with a noise complaint, and then that turned into this whole full accessibility, accommodation, fairness, and procedural law analysis. And so some of the key facts from this case, Ms. Baja, the owner, and her partner, Mr. Murphy, both moved in with dogs. And so the condo had a rule that there can only be one dog per unit. And the complaints, which only came from one person, and ironically, that was the board president who was living below them, and they complained about barking. And so both residents said that their dogs were service animals. They provided medical documentation multiple times. Yet the board continuously demanded additional medical details, and they wanted details on symptoms. And so it escalated to the condo claiming numerous barking complaints, which the CAT found unproven. And the board challenged the legitimacy of the medical evidence that was submitted and insisted that Mr. Murphy prove why this dog was required and not some other accommodation. And the result was initially, at least, the CAT dismissed the condo application. They allowed the second dog, and they awarded $15,000 in damages, as well as a small common expense credit. And so the condo appealed on four main questions. Question one was, did the CAT apply the wrong legal test for disability accommodation? Question two was, did the CAT prevent the condo from properly challenging the accommodation claim? Question three was it procedurally unfair for the CAT to award damages? And question four, did the CAT err in exempting residents from certain common expenses? Spoiler alert, the condo lost on all four grounds. So issue number one, did the CAT apply the wrong legal test for disability accommodation? The court held that the CAT correctly followed the accommodation principles under the Human Rights Code. And the medical evidence was clear. Mr. Murphy had a disability, and a service dog is necessary for his symptoms. And so the condo demanded diagnosis details and alternative accommodation proposals as well. And that's not legally permissible. And so the court held, they cited the Ontario Human Rights Code policy, which pretty much says a condo can't substitute its own opinions for the doctor's, and it can demand intrusive medical details. So if a medical professional says a dog is necessary, you don't get to say, what about a goldfish instead? Issue number two is, did the CAT prevent the condo from properly challenging the accommodation claim? And so the CAT cut off certain questions about the dog's background and Mr. Murphy's diagnosis, and the divisional court said that was fine. The CAT could manage its own process, and the questions were actually irrelevant. And it would have required prohibited medical disclosure. And the condo was not prevented from making its case fairly. Issue number three was it procedurally unfair for the CAT to award damages? And so under section 1.44 or section 1.44, subsection 1(3) of the Condominium Act, the CAT can award damages up to $25,000. And so the condo argued here damages were raised way too late. And so the court disagreed with that, said damages were already an issue earlier. Condo had the opportunity to respond, and the CAT reasonably accepted unchallenged evidence that the residents had to move out for 5 months due to stress. And that was about $15,000 in ownership costs. And then issue number 4, did the CAT err in exempting residents from certain common expenses? Ultimately, the condo challenged up about $100 credit, and the court responded basically by saying, don't waste our time. There's a rule that applies. It's called the de minimis rule, and that pretty much means that it can be disregarded because of its insignificance. And so the appeal was dismissed. And so some important legal principles from this case. First off, the Human Rights Code does override the Condominium Act, and that includes the condo governing docs as well, so the declaration, bylaws, and rules. And so even if the condo has this perfectly valid one dog rule, this pet prohibition, those rules can't be applied in a way where it discriminates on the basis of disability. And human rights accommodations, those aren't optional. And it does not require the corporation to approve it. Once a disability-related need is supported by proper medical documentation, the corporation's obligations are immediately triggered. And so this case demonstrates how a condo corp gets into trouble when it focuses on technical compliance, like saying our rule says one dog, rather than focusing on the human right framework, which would ask the question, does this resident need this dog because of a disability? Another important takeaway or legal principle from this case is when you're looking at medical documentation, you have to take the least intrusive standard. And so boards typically believe that they're entitled to detailed medical files before granting accommodation. And so this case reaffirms that that is actually not the law. Condos can ask for confirmation that the person has a disability. They can ask for confirmation that the accommodation is required because of the disability. They can ask for a statement connecting the accommodation to the disability-related needs, but there's a lot that the condo can't request. They can't ask for the diagnosis, can't ask for symptoms, or the treatment history, or the nature of the disability, or even details about how the service animal assists the resident, or even the resident's entire medical file, or a justification for why that particular accommodation is needed, or a request for alternative accommodations, like why not share one dog? Can't do that. And so the condo's right to ask for medical information, it's not a fishing license, right? You have to respect the resident's privacy and dignity. Next up, it's also, in this case at least, there was just one complainant, and that doesn't automatically mean that there's a nuisance here. So the condo claimed that there were numerous noise complaints about barking, and the CAT determined based on evidence that only one complainant existed, and that's the board president living below. And there was also no objective evidence of unreasonable noise or ongoing nuisance. So the occasional bark is not a violation of Section 117.2 of the Condominium Act. And it's quite true that boards sometimes assume that because someone complains often, the problem must be real. But the court made it clear in this case that nuisance has to be proven with objective, credible evidence and not just personal frustration. Another important legal principle in this case is damages for discriminatory treatment. Like this is huge. The divisional court upheld the CAT's award for $15,000 in damages. That's substantial in the condo world. And so the court did reaffirm that the CAT can award damages up to $25,000 for discriminatory or unreasonable conduct under Section 1.44. And the damages here were justified because the condo's approach caused significant stress, they worsened health impacts, they forced the couple to actually leave their home temporarily. And so the award included costs such as mortgage interest, taxes, condo fees for the period that they were displaced. And so that's really important. Like this case does send a message that if a condo mishandles an accommodation request, there's real financial consequences for that, plus potentially bad press too. And so some takeaways that I wanted to jump into. One, it's important that boards are trained on accommodation law, and I seriously mean that. Boards should know what medical information is allowed to be asked, what questions are prohibited, the steps of accommodation analysis, and when to actually seek legal advice. That would pretty much avoid the prove your illness approach that led to damages, at least in this case. Another takeaway is don't build an enforcement case on just one complainant. Any noise issue should have logs, it should have independent evidence, it should have like staff observations. Another nice to have would be decibel readings. So one person's subjective annoyance does not mean it's nuisance. Another takeaway is engage legal counsel early, but make sure there's strategy behind that. Legal counsel should help guide the accommodation process. They shouldn't be instructed to go and start sending letters or demands for more documentation or more information. Counsel should be helping the board understand what needs to be asked and what should not be asked. And you don't want to go for heavy-handed enforcement in situations like this. Another takeaway is documentation, document enforcement all the time. So if the board ignores similar violations but enforces against a resident requesting accommodation, that's risky. It's easy to then make a finding of discrimination. There's damages associated with that. There's a loss of credibility at the CAT level or at the court level. And so you really need good documentation. That would be your best defense. The last takeaway that I wanted to mention is never treat accommodation requests as a private interest. The court in this case called the condo's framing as a significant mischaracterization. And so accommodation is not a favor, it's a right. Overall, this case does remind us that condo governance is not just about rules, it's about people's rights. And when a qualified medical professional says a service dog is required, the board's role is not to cross-examine or challenge that, it's to really accommodate or respectfully, like at least respectfully accommodate that and make sure that you're in compliance with the law. And that takes us to the next slide.
All right, so we're going to wrap up our cases with a quick discussion of some problems you might see when it comes to board governance and decision making. Specifically, what do you do when the board just can't make a decision and there's dysfunction and chaos all throughout? So the decision is Leduc et al. The Ottawa Carleton Standard Condominium Corporation, number 758. And in this case, we have a Mr. and Mrs. Profasi, who were spouses and directors on the board. Mr. Profasi, in particular, commenced this application for the nuclear remedy of appointing an administrator and inspector over the condominium corporation. His principal complaint was that an allocated cost contribution fee under a shared facilities agreement was administered in a way that let a large corporate owner in the corporation, who held over 50% of the voting units, it let them off the hook, and that the board was in a stalemate and couldn't do anything about it. So, for background, the appointment of an administrator and inspector under the Condo Act is an extremely rare remedy where the court appoints an independent party to effectively assume all control and powers of the corporation because the board is unable to carry out the corporation's objects and duties, often due to extreme dysfunction. Self-governance under the Condo Act is considered the norm. The appointment of an administrator and an inspector is considered a last resort remedy. So the issue in this case was whether the high threshold to appoint an administrator and an inspector was met. So for some background, this board did not meet for approximately 10 months. However, the evidence showed that this was largely because the Profasis refused to provide their availability or attend meetings, effectively blocking quorum at a meeting and halting governance. Now, the corporation's board of directors were composed of five positions, but there were only four directors on the board, leaving one vacancy. While the stalemate could have been resolved by potentially appointing a director to the vacant fifth seat or electing a director to that position, decisions otherwise were locked in a 2-2 stalemate between the Profasis and the other two corporate owner affiliated directors. The Profasis claimed that filling the vacant position wouldn't resolve the governance issues, since the other two directors who were affiliated with OML would naturally select a director who would remain affiliated with OML. So in response to this, the court noted that the Condo Act vests in the unit owners the power to manage the affairs of the corporation through an elected board. The fact that a majority of the board may not share the Profasi's views is not a reason to appoint an administrator. The relevant inquiry is whether the board has demonstrated an inability to manage the condominium's affairs, not whether board management is to the satisfaction of any individual member. In short, the court refused to appoint an administrator and an inspector before the board could have a fair opportunity to fill the vacant seat. The court found that the Pravasi's position was disingenuous and that they effectively grounded the corporation's work to a halt in an attempt to get their way in illegal proceedings, and that this was not in good faith. There was no substantial mismanagement, and there was no necessity to bring an order that only an administrator or an inspector could achieve. So the takeaway from all of this is be reasonable above all. And that's, to me, a very broad takeaway that could be applied to any situation in condo living. It's important to remember that as for unit owners, condo living is a democracy. The owners have the right to elect their board of directors. The idea being that they would presumably elect someone who will act in the corporation's best interests and do what's best for the owners. On that note, owner engagement is critical. Owners can't complain about the board's decisions if they're not participating, and it's no different for any of us in our municipal, provincial, or federal governments. So the takeaway for that is governance is tricky, but being reasonable is often the best guiding light.
Yeah, and a court-appointed administrator is an expensive endeavor for any corporation and an extreme step to get to, absolutely. We have some fantastic questions though, so I am glad we have a little bit of time to address some of them. Gersh, I absolutely loved your advice on what questions you can and can't ask. We're getting amazing feedback that's very valuable. And we got a situational question that's very interesting. It says an owner of a townhouse unit with a driveway is demanding accommodation from the corporation to have one of the visitor parking spots designated for him. So this situation kind of opens up a whole bunch of questions to ask, such as why, or along the lines of the questions that you outlined for us. Do you gentlemen have any advice on how to handle this situation with that limited information?
Yeah, I think Gersh, not to pass the buck off to you or anything, but this is something I think is up your alley since you covered the Baja decision. But it's with the limited information we have, it's not clear why this owner might be requesting the visitor parking spot for accommodation. I'm assuming they have a disability, but is that disability being accommodated by granting them the visitor parking spot? Is the visitor parking spot closer to their unit where maybe they don't have to walk through a couple of difficult steps? It's all very ambiguous, but I will say that there's a difference between having a disability and having an accommodation that addresses that disability. Having a disability is not a freestanding right to get any accommodation you want. And that goes to Gersh's comments about undue hardship. Gersh, did you have anything to add to that?
No, it's missing context, like you said, Tony.
Mhm.
There is some more information that we could use here. But I think Tony mentioned all the pertinent points there.
We also have a great, very spicy question. What is a board director's responsibility, legally or ethically, when an owner has a complaint against the property manager? I love this question.
I mean, did you want to take the lead on this? Or I'm happy to do so. I guess at a very basic level, the board has to consider the complaint in good faith. It can't just dismiss it without reviewing it or, dismissing it on the basis of who is sending the complaint. Really, the board needs to look into it and see if there's any merit. And it might just be that as soon as you read the email, you go, there's no way this is realistic. But at least you can say you considered it.
I agree with that. I think there's quite a bit of case law that says there's a duty to investigate. And so you do want to take the complaint at hand, see what's going on, ask for further evidence, have this off the record conversation to ensure that management's not actually directly involved. So if it's, I usually recommend having owners send physical letters to like to the corporation. You can review it and write back with a physical letter too. But if you can just keep property management off the record, off the email chains too, that's perfectly fine. But definitely investigate. Even if you love your property manager a lot, there could be some concerns, and take it as constructive criticism. It doesn't mean you have to change the whole world, because changing property management teams is like changing the whole world. It's quite extreme. So take a look, investigate, and improve if you can.
I would respectfully disagree with a little bit of that, just because I think you would want to involve your condo manager, because anytime there's a dispute, you want both sides of the story and you want to know, was that person just sent a lien? What was the dispute? But absolutely, the evidence should speak for itself.
Yep. So that ties in the whole duty to investigate. So definitely you have to hear that side of things too. So thanks for
Yeah.
making it clear, Karen.
Yeah. So that's a good one. They also go on to say that a director slanders the PM in an email to the solicitor of mishandling corporation funds. Unfounded, fabricated, goes on to basically say the condo manager has been accused of items that are not reasonable, goes on to say that they need psychological help and that they're unfit to do their job. The PM they also take every opportunity to tell others. So they're gossiping about the PM, obviously not creating a very good work environment, and telling others that the PM is difficult. The PM's an honorable, professional, transparent, friendly person. So what do you do when you have somebody who is maliciously attacking, not even your PM, because this could happen to a super or any staff member or employee or contractor of the corporation? So what would be a good first step to address this with a director?
I'll quickly jump in. One of the defenses to defamation is truth. So I would ask for supporting evidence of every single claim that is being made to see if that defense would actually apply here. Otherwise, you can call it for what it is. That is defamation, slander, libel, and there's consequences to that. So it needs to be shut down if there's no supporting evidence for those claims.
No, and just to echo what Gersh has been saying, it's if the board staunchly supports the property manager and it has reasonable grounds to do so, it's not just taking the property manager's position for the sake of it, then it should stand up for the property manager because first, property managers are an invaluable resource to your community, often the backbone of any condominium corporation, with all due respect to the board of directors. The property managers are the ones who are on the ground. They're on the front lines, actually interacting with every single owner, and unfortunately, sometimes being subjected to their harassment or abuse. So if the board thinks that there's an improper complaint against a property manager, it makes sense to reaffirm their support in the property manager while, of course, properly investigating the complaint.
Wonderful. Do we have time for one more? How do the standards differ between a certified service animal, guide dog, diabetes alert dog, etc., and a pet deemed to be an emotional support animal?
I
Um,
think I get the shot of this question, but I'm just it's worded a bit uh,
And
awkwardly,
condo managers
with
do
all due
struggle with
respect.
this a lot when things are submitted, evaluating them reasonably and with accommodation law and proper certifications. How do I know whether this is a full accommodation? It is a point where we struggle with it a lot, especially considering there's different notes, different professionals and stuff like that. My advice would be if you are confused or uncertain about it, you can always have a legal review of the documentation and advice to the board, because that is the way to say, look, I did investigate it. I did try to figure out if this was thorough and true and something that needed to be accommodated, which I think was one of Gersh's original questions. And I do apologize. I wish I could get to every single one of the questions. There's some really good ones in there. So thank you all so much for those of you that submitted them. And with that, I can go through the closing slides. Thank you. Okay, wonderful. So today we covered a lot of really interesting topics: harassment, chargebacks, accommodation. We touched a little bit on service animals and disability rights, and how it is nice to err on the side of accommodation. As a condo manager myself, it's nice to express things in the most caring manner that you can for your clients as well, as long as it's reasonable and the impact on the other residents is reasonable as well. Governance and court-appointed intervention, the severity of those cases as well. So wonderful reviews today, gentlemen. Thank you so much for your time and for answering the questions that we could get to. We really appreciate that.
No, thank you for having us. It was a pleasure.
I echo that.
Absolutely. And for the attendees, please fill out the webinar survey. It does help us improve and create topics and seminar and webinars that meet your needs. So we do really appreciate the 2 minutes that you take to give your honest feedback. We also have some fabulous upcoming stuff through CCI, unlocking the secrets for new owners and boards. We have the level 100 coming up in St. Catharines on December 4th. Hope to see you there. There is the Condo Sun, Snow, and Statutes, comparing condo obligations from Florida to Ontario, coming up on December 9th. And of course, please visit our website. We have all of these exciting events and opportunities posted with full descriptions. And that is the best way to keep updated and make sure you don't miss anything. Thank you again for joining us today. We really, really appreciate it.
Thanks, everyone. Thanks for having us.
And
Thank you.
thanks again to our sponsors, Property Right. We really appreciate it.